Well, good afternoon, ladies and gentlemen. Welcome to our final panel of the day. I'm pleased to have the opportunity to moderate it. I'm instead of from one of the seats for the very practical. My notes, brilliantly printed up last night, thoughtful, clean, sequential, have all been torn to shreds by various speakers today. I've got sticky notes, I've got little bits torn out of notepads to account for a lot of the very thought-provoking discussions that we've had today. I have learned a lot and hope you have found the time valuable as well. Our final panel today is on senior legal counsel perspectives on space law and responsible behavior. I'm going to open our panel today with a couple of thoughts of my own and then introduce the panelists for this afternoon. I'll invite each of our panelists to make some opening remarks, and then we're going to open things up for questions. I'll start with a couple myself. However, this panel is going to include more time for questions from here in the room, from the online community. The goal today really is to foster a discussion about what's on your mind. And the speakers we've talked in advance and really want to speak to what is on your mind about the topic today. We've talked about a lot of the non-binding things out there under different monikers during a lot of the discussions today. And those different non-binding things, non-binding agreements, if that's such a thing, norms, to the extent we've talked about those. And oftentimes those non-binding things are used for different purposes that we sometimes conflate as lawyers when we're talking about what meaning, what impact, if any, they have for our clients' proposed activities. They may refer to efforts to develop customary international law, intentional efforts to advocate for the law to develop in a certain way. They may refer to these written or perhaps verbal but unwritten non-binding arrangements for whatever force and effect they may have. Or they may be purely internal guidance, such as the Secretary's Tenets of Responsible Behavior for Department of Defense space operations. Those are all very different purposes, but they all have a common thread that runs through them, and it's a thread that I think this panel represents very well, and that is state practice. We've mentioned state practice a bit during the course of the conference so far, but haven't really dived into it. But I think this panel really is going to bring some great perspectives on state practice. State practice, of course, over time, and if it is performed through a sense of legal obligation, can develop into customary international law. Of course, state practice also can inform how we interpret different treaty provisions that are already codified as treaty law. Some of the earlier speakers have discussed the difficulty in today's international political environment, which I think is safe to characterize as in many quarters a low trust or a no trust environment, depending on the state actors that we're talking about. It's difficult to develop new written rules, given the lack of a consensus or the inability to develop a consensus as to what that rule can be. And nevertheless, we do continue to develop the law through state practice. And obviously, the lack of increasingly specific written rules has not slowed down that state practice. Space is more congested and contested than ever, and the pace of space operations only continues to increase. One of the earlier speakers noted that commercial actors are moving faster than the law can reflect. And I think that's a very fair statement as far as written law goes, but those commercial actors, among other spacefaring actors, are still developing law through different state practice. And when I mention state practice, of course, that's not only the practice of actual nation states through their militaries or their civic organizations, their civil organizations. That includes non-governmental and commercial actors, because all human activity in outer space falls under some form of national responsibility under the Outer Space Treaty. Those forms of national responsibility differ from the kind of responsibility we see in other domains, but nevertheless, it's a form of national responsibility and state authorization. So our panelists today embody this, this idea of state practice as senior legal advisors for the different national and international spacefaring organizations. They are very much guiding state practice at the highest levels with their legal practice and with the work that they oversee. I'm very eager to hear their perspectives on space law and responsible behavior today. So let me get on to introducing our panelists. First, at the far end of the stage, Lieutenant General Jeffrey Rockwell is the Judge Advocate General for the Department of the Air Force. In this capacity, he is the legal advisor to the Secretary of the Air Force, the Chief of Staff of the U.S. Air Force, the Chief of Space Operations, and all officers and agencies of the Department of the Air Force. He directs all Air Force judge advocates in the performance of their duties and is responsible for the professional oversight of more than 2,200 judge advocates, 350 civilian attorneys, 1,400 enlisted paralegals, and 500 legal support staff civilians in the total force Judge Advocate General's Corps worldwide. General Rockwell has served as a staff judge advocate 5 times, including as staff judge advocate for Air Force Space Command, and the U.S. Space Force was established during his tenure as the Judge Advocate General. Air Vice-Marshal Tamara Jennings is the Director of Legal Services, Royal Air Force. In this capacity, she is the principal legal advisor to the Chief of the Air Staff and to the Air Force Board of the United Kingdom. Prior to her military service, she qualified as a solicitor in 1998 and practiced law in Newcastle upon Tyne before commissioning into the legal branch in 2000. She served in various RAF commands, including as leader of the RAF Service Complaints Team, for which she was recognized as an officer of the Most Excellent Order of the British Empire. And last but certainly not least, Dr. Marco Ferrazzani is head of the Legal Services Department, European Space Agency. In this capacity, he is the legal advisor to the ESA Director General and to the ESA Council for all institutional and legal matters. He represents the ESA to international conferences such as the Legal Subcommittee of the UN Committee on the Peaceful Uses of Outer Space, and sits on several boards, including those of the European Center for Space Law, the International Institute of Space Law, and the German Journal of Air and Space Law. He was recently awarded the honorific title of Cavalier by the President of the Italian Republic. So I'll turn the floor over now to our panelists to offer a few opening remarks. And Lieutenant General Rockwell, sir, the floor is yours.
Thank you, Colonel Pennington. Thank you for the invitation too. This has been wonderful for me. I haven't sat through one of these conferences for 25 years. I mean, I go to them and I get to participate in them, but I never get to sit there and listen. And I think I was one of these majors a long time ago sitting there. And I remember what I thought when I had to sit there and listen to somebody like me speak. And it was usually, would you shut up so I can ask you a question and show you how brilliant I am? Just a couple remarks, and I want to focus on the topic here, senior legal perspective, and I want to talk a little bit about what was different 25 years ago than today. And I didn't really realize why I was here until Colonel Pennington just said, I guess what we do add to this, we're practicing space lawyers. And I've been doing it for 25 years. I say that because I feel like I don't have anything to add to this group other than that, because there's some brilliant panels that we listened to over the last couple of days. And so I really thank you for letting me participate and listen to this. The stand up of the Space Force and how that all kind of came out. I wanted to talk about that a little bit, because when I came in the Air Force, unlike most of you, we didn't have a U.S. Space Command, or you didn't have it. I had one. And as much as this seems new to some of you, it's not. We had a U.S. Space Command back in '85, and I entered an Air Force with a Space Command. And we had a U.S. Space Force and a Space Command who did a lot of the things we do now. And as you're setting your culture out there, which I think is phenomenally important, incredibly important to do, What do we take from the past to apply it to the future? It was interesting when we set up a new force for the first time since 1947. We did what we always do as government attorneys. We pulled out the old legislation and said, how do we do this? And we pulled out the Navy Marine Corps model and said, hey, let's do this, which was pretty cool. Why was it cool? Because the third line of the legislation said there will be a JAG to the Space Force, to the CSO and to the Vice CSO. And I took that, I was very proud of that. I thought, we're the third most important person in this room. And I thought that was cool. But what it made us reflect on is, do we need a separate JAG Corps for the Space Force? The bureaucrat in me, the manpower person in me who just wants more bodies to do work said, absolutely. Let's set up a whole new JAG Corps that's a Space Force JAG Corps. And that forced us to step back, relax, start thinking about what do we do across domains? And how do we look at space law, which I'll get to in a minute, which is the second part of the title of this presentation. What do we do in space from a national security perspective? And is space really that different? I know every one of you think it is. You're proud of the fact. You wear your patches, you talk about space, you talk about the technology, and it is pretty cool, but I'm not too sure it's really that different from a legal perspective, from a national security law perspective. I know that's heretical to say in a group like this, but I'm a space law person and I think I'm allowed to. The second thing I want to talk about before we get into the rest of the panel is you've heard integrated deterrence spoken a couple times. And this is the second reason why I will tell you that we just went with one JAG Corps for two forces under the Department of the Air Force. If you're wondering what this concept of integrated deterrence means, at least to my bosses, and when I say bosses, I got a bunch, but the three main are the Secretary of the Air Force, the CSO, the Chief of Space Operations, and the Chief of Staff of the Air Force. I learned a long time ago as a young lawyer to know your boss's job and your boss's boss's job. Incredibly important. Well, all my bosses talk about is integration. Integrated deterrence, integrated across domains, integrated with their bosses, integrated with the Department of Defense, integrated with all the services, integrated with all the service secretaries. Integrated even further now with all the instruments of national power. Again, back to why do we need a separate legal advisor to space and air? No, because when you look at the integration across the services, across the joint staff, across the interagency, and across the areas of the law, it all has to be integrated if we're going to compete in this great global power competition that we're in. Second part of this, the title of this, space law. Right? Is it really space law? Or is it the application of law in space? It's an important distinction. It's an important nuance. You guys talk about space law all the time. I do too when I was doing it. But is it really space law as a separate discipline? Or is it the application of all of our legal areas in a new domain that really isn't new because we've been in this domain for a long time? The only thing new is the explosion of the economics of space right now, and that's driven by launch more than anything. And so I would ask you to start thinking about how do we approach the law in space. And I love the discussion over the last couple of days because we talked a lot about what space law means. And we talked a lot about the international law aspects of treaty, of custom, of norms, of rules. But I would ask you, is that form over substance? Did I say that in front of a room full of international lawyers? As an international lawyer, crazy talk, isn't it? But it is an interesting, at this stage in our evolution of the law and of the domain, Is it really a form over substance way of looking at things? The way we look at space law these days is that it's an aspect of national security law that includes every civil law issue, every international and operational law issue, and yes, every discipline issue. When I was the major sitting in the audience, we talked a lot about crime in space, which was an interesting philosophical academic discussion. But now that we talk about space to, from, and in, not necessarily in the domain itself. So even the military justice and disciplinary aspect of this is all pulled into space. So let me finish with the last part of this, then I'll turn it over to my colleagues. Responsible behavior. All right, here's a warning, another old man comment from the stage. What is law but a framework to regulate behavior? I don't care where you are, what domain you're in, what type of law you're talking about. Law is nothing more than a framework to regulate behavior. Just an editorial comment from sitting over there listening to y'all. Just so I can throw a grenade and get you spun up so you throw stuff at me in a minute. We conflate a lot of issues. We did over the last couple of days. And we never once ask ourselves, what behavior are we trying to regulate? Are we trying to prevent an arms race in space? Are we trying to do weapons control? Or on the other hand, are we trying to create a framework to hope we get innovation? And what's interesting about all your perspectives is you don't distinguish between those things. Sometimes we have to prescribe law. Sometimes we have to proscribe law. Sometimes you have to prevent, sometimes you have to facilitate. And that's fundamentally where the difference is in the approaches of what we hear across the board, whether you're military, whether you're in academia, whether you're in business. It's a reconciliation, but we never ask ourselves, what behavior are we trying to regulate here? What framework are we trying to create? Proscriptive or prescriptive? And so I do love the conversations about treaty versus custom and practice. I love the conversations about, should we use norms or rules? Does it really matter to the operators in the audience at the end of the day? I love the discussion. Most questions and most discussions have this tone underneath it of, are you an internationalist? Are you a globalist? Or are you a nationalist? Words we don't like to repeat, but a lot of that, as we try to regulate behavior, that's how we're looking at things. And it's interesting from the military folks who always think they're nationalists by definition. National security and national defense means US. Whereas when you look at business and the economic instrument of power, that's definitely internationalist and global, isn't it? Tension there. Which gets me to the real point of where I think we need to go, which this is a basis for the discussion of these comparative law studies that we need to start talking about a little bit more. And how do we lay out the differences, not just with our competitors and adversaries, but with our allies? We all approach law differently. And there is nothing wrong with that. Does anybody in this room really understand why we don't sign treaties? We throw it around, we get sort of criticized for it, but do you really understand why? And a lot of it is the basis of our system, our common law systems, or our civil coded systems, or are you a rule of law person or a rule by law person? And that lays out some of the differences in the legal philosophies and the systems we looked at. I love Professor Beard's soft law versus hard law discussion, because that's another interesting dilemma and an interesting debate that I want to hear more about from you all. And I would ask, does it really matter if it's black letter law or treaty law or custom and practice? How much of this discussion is driven by this one question? What's the enforcement mechanism in international law? The realist in me says there isn't any. That's why it doesn't really matter whether it's a treaty or a custom or a practice. And how do we get to where, if we can ever get there, to where there's a real enforcement mechanism in reality in international law? Turn it over to you, Tam.
So thank you very much. And how do you follow that? Carefully. The first thing I wanted to say, and I think it echoes what everyone else has said, is a huge thank you to the organisers and to everybody who's participated for the invitation. I've learned a huge amount. I know I've been the annoying person at the side asking all the questions, but I'm genuinely interested in what our speakers and our panels have had to say. And I've learned an awful lot, and it's made me think about some of the terminology we use. And I've had a little bit of an allergic reaction to some of it, if I'm honest. I sort of sat there and gone, actually, why do I dislike that? So that's something I'll probably touch on in a minute. So it's really made me think. But what it has done also is really underlined the importance, both to me and to the UK, and I think to all of us in this room, about international partnerships and alliances and the importance of understanding and listening to what our allies and partners are saying, what bothers them, what doesn't bother them, what keeps them awake at night, and what actually they're quite comfortable with, because all of that helps us when we have to work together. So for that, this is a really important conference for me. And like the General, I normally don't get to sit and have the luxury of 2 days just absorbing myself and listening and learning, and it's been a real privilege, and it's been fabulous. So before I start, I'm going to have to do the standard disclaimer, and I'm going to do it for 2 reasons. The first of which is the right reason, which is everything I say is the view of me alone. It does not represent, Her Majesty's government. It does not represent the MOD or the Royal Air Force, because that's the right thing to do in these circumstances, because you never know what I'm going to say. And that's the second reason that I'm going to give that disclaimer, because anybody who knows me also knows you never quite know what I'm going to say. And sometimes it might be really uncomfortable for my friends from the FCDO in particular. And so I will gauge my comments based on the level of horror on David's face. But if I say something that the UK would absolutely disagree with, clearly I'm an idiot. And the UK are right. So let's just get that out there and in the open. And then the other comment I was going to have is about being a major and being a squadron leader in my parlance in the audience. And I have 2 of my squadron leaders here, both of whom know far more about this subject than I do. One works in Space Command and one's doing a PhD in space law. So both of them far more qualified than I am, and I go back to my earlier idiot comment, than I am to sit on this panel. But when I was in their position listening to this, I didn't want this, someone, as ancient and decrepit as the General to finish. So that I could ask a deeply insightful question. I just wanted them to finish so I could go to the bar. And I do appreciate that this is the thing that stands between us and another happy hour. Far be it from me, therefore, to overrun. So I've got 2 real points. The first of which is to talk to you a bit about what the UK are doing and a bit of an insight into what we're up to in terms of space, just because, well, I think it's interesting. Whether you do or not, you have to listen. And the second is, again, to talk about this idea of space law. And I'm with the General here. I gave another presentation at Harvard a couple of days ago in relation to urban siege warfare, another subject on which I'm not an expert. And what struck me is I could have done that presentation like this one in a couple of seconds and been done, because it's all about context, baby. The law is pretty much the same. We talk norms, we talk behavior, but the law is pretty much the same. It's about how we apply it in the context we're in. Drop mic, I'm done. But I will give you a bit more. So the first point, the UK has been busy over the last 12 months. We're playing a little bit of catch up with you. We issued our National Space Strategy in September 21, which sets out our UK civil and defence space policy framework. And underneath that sits our defence space strategy, which we issued in February of this year, so pretty hot off the press. And that talks about the vision for the UK. And what do we want to be? Well, the UK wants to be a meaningful actor who, alongside our partners and allies, sort of secures UK interests, but also preserves our freedom of operation, freedom of movement. And to do that, the UK is investing for us what is a load of money. Now, I appreciate it's all again about context and how big your budget is, but for us, 7 billion over 10 years in Skynet and an additional 2 billion as a result of our defence space strategy is a big deal. From a UK perspective, that sets out our stall that we care and that we're invested in space. And we've set up a UK Space Command in April last year. And that's to operationalise, if you like, what's in the defence strategy. And that's at High Wycombe, where I'm based. It sits under the Air, top level budget, but it is its own command and it's jointly staffed. So we have people from the Army, the Navy and the Air Force, albeit predominantly about 70% is the Air Force, because guess what? Air and space, really close. You know, there are differences of opinion where one ends and one begins, but fundamentally we all agree they join at some point. And so the Air Force does 70% of the personnel in that room. And it's an area, they therefore sort of are responsible for the day-to-day business in 3 functions: operations, workforce training and growth, which to be fair is where they're really focused at the moment because it's new, and space capability. So that's all about buying stuff. And space itself, although I'm saying that this is a really big new thing, we're playing catch up, the UK's actually been involved in space, you know, like you, for a long time before we set up a space command. You know, my lawyers have been going to the Shriever War Game since I would have been sitting in this audience as a squadron leader. You know, we've been doing this for many, many years. I've got 2 people doing PhDs. I've got one hopefully about to start a master's. We've run our own internal space course that's been delivered to all of my lawyers. We're starting to educate some of the other services. And we've mentioned and we've heard about Woomera. The UK rep to Woomera in his own capacity is an RAF wing commander. You know, one of my PhD people who are studying. And so, you know, this is not new for us. This is something we've been interested in for a long time. If I move on from that to my second point, and I think while the UK's been busy, so has everybody else. And it would be remiss of me not to identify that some of our partners and allies, you know, the Australians and others, we're all going through our own iteration of what Space Command looks like, what we want to do in space. So everybody is doing this. This is not the US, just the UK. Everybody is starting to think about this a lot more and starting to develop their own systems for how they're going to function in this environment. But the UN open-ending working group, you know, that group is looking at reducing space threats through these idea of norms. And I said I'd talk to you about things I'm allergic to. Soft law is a phrase I instinctively shudder at because I'm kind of like, well, you know, as someone said yesterday, well, you know, if it's soft, is it really law? Not really. It's not law. Law's law. It's either law or it isn't. If it walks like a duck and quacks like a duck, then it's a duck. Otherwise, it's just an imposter pretending to be a duck, you know. So soft law is something I have a real instinctive shudder when I hear the phrase. I understand what we're trying to do, and I understand, and I don't disagree that where it's really hard to create law in a different way, that nudge effect, you know, you see it in other things, that nudge, that influence, that trying to get people to just move a little bit on the dial, all to get a bit closer together, why that's a really important thing to do in the absence of the ability to get everyone in a room and maybe negotiate a treaty or do something else. But let's be under no illusion, certainly from my perspective, the idea that we're going to create norms that are just going to be not legally binding is to me a complete fallacy. Because guess what? If everyone starts to follow them, they're going to become customary international law at some point. So if we sit here and say that that's not the case, from my perspective, I think we're probably deluding ourselves. But you know, feel free to tell me that you think that I'm completely wrong, in which case you'll probably be right. But And then the other thing I wanted to highlight is, certainly from our perspective and my perspective as a military lawyer, space isn't just this thing that is on its own somewhere. It's connected to everything we do. There's not a domain that's not impacted by space. And so the idea that we just talk about space in a bubble, for me as a lawyer, is really difficult, because when we talk about space, it's about what it's going to be doing. What's the effect that we're having on the ground, in the air, in the cybersphere, whatever it might be, on the sea. So the idea that space in its own right is just an entity. Now, there may well be things that happen in space and it just stays in space. But the reality is, why do we care? It's because it impacts us down here. It impacts what we try and do. So space is intrinsically linked to our, our national, regional, and global security. And that is why, by the way, that from a UK perspective, I don't lead, the military do not lead the discussions on what should be happening in terms of space. It's our Foreign and Commonwealth and Development Office. It's not just a military question. So I did write, and I hesitate to say this in this company, I did write a paper which thankfully was not marked by lawyers when I did our higher command and staff course. And such actually is the interest in space. I had a free rein on what I could write on. And I wrote on the responsible behaviours in space in the UN piece that had been done by the Foreign and Commonwealth Office. And, I did quite well in that, mostly because it wasn't marked by lawyers. But ultimately, I talked about the importance of relationships. And even if you're looking at norms as opposed to, treaty law, fundamentally, it's about relationships. It's about getting the parties that matter to try and come around a table in some way, shape, or form, be that virtually, be that through making commitments. But if you don't get that from the major players, this nudge theory just isn't going to work. So I think the best way to do it, and it reflects in one of my questions that I asked right at the outset, is to focus on what good looks like and trying to get commitments of how people are happy to sign up to behaving in terms of being responsible, rather than trying to define what bad looks like. Because if you have enough about what good looks like, you can then start to work out what isn't good. But I think trying to ask people up front what's bad and asking people to define what they think is going to be a threat is really difficult, because everyone wants to keep their cards close to their chest, which comes to my other point from yesterday. That whole classification thing, this is all secret. I can see the benefit in that, because it also means when it comes to state practice, well, guess what? We don't tell anyone what our state practice is, because it's hidden behind layers of classification. So the law, as it's set out in the treaty, in the Outer Space Treaty, I love it, because it's a set of principles, the interpretation of which is open to us to decide based on the context. And in the space domain, you have even greater freedom, because nobody can see you when you're actually deciding what your context is and what your answer is, because it's behind a veil of secrecy. So trying to get at what state practice is, trying to look at what the Russians are doing, the Chinese are doing, really difficult, because they're not going to show you. So I will stop, because I've got a whole load of other stuff I could say, but I suspect there'll be stuff in questions. But for me, communication, nudge theory is probably the best way at the moment to get us to a position where we might get to develop some customary international law in this area. But be careful what we wish for, because we don't want to impact our freedom of movement too much.
Thank you, ma'am. Dr. Ferrazzani.
Distinguished colleagues, first I would like to thank the United States Space Command and the Air Force Academy for the invitation to be here. I'm really thrilled, and I was pleased to follow the debate today. I have the honor to participate in this highly distinguished panel and talk about the broader topic of responsible behavior. From my perspective, as I've been able to gain as the legal counsel of the European Space Agency in the last 12 years of service. And I will follow up with some slides. ESA is a civil agency comprised of 22 European states, and we work closely with our member states, with the authorities, with the defense authority, with the private initiatives, and develop the growing European sector. As a civil space agency, ESA tries to go above and beyond what is required by international standards of space law and also by technical standards. And I'll try to demonstrate that to you today. Because we implement our own model, which is not one nation, is a multilateral system of many nation states. And also as a possible source for inspiration to space operators, contributing to various programs in Europe, like EU secure connectivity, space traffic management, the European Galileo system, enabling governments and to emergency response and threats facing any kind of crisis. But for us in the space and legal profession, responsible behavior has grown a lot in importance in the last few years. But however, responsibility is not a topic only of the space sector, of course. When I look at the US Secretary of Defense tenets of responsible behavior, which have been mentioned, I see it's a welcome initiative towards a more uniform and balanced use of outer space assets. And I can see practices and behaviors of the past that have been already contributed largely towards these goals. So it's a welcome development. For instance, and this I want to mention, we mentioned today due regard to others. This is Article 9 of the Outer Space Treaty that says states shall conduct all their activities with due regard to the corresponding interests of other state parties. In reality, environmental concerns were not the primary concern in the early days of writing this treaty. It was more about disarmament at that time. Today, we have seen there are considerable developments of space use, especially since the adverse changes in the surface of the atmosphere and the impact that can receive for space traffic. This has been mentioned earlier today. So new space flight developments would require balancing the exploration and the use of space with other interests of other ground interests. And I agree with General Rockwell about the fact that we talk about space law, but in reality, we talk about how the law that we have on the Earth apply to space, and back how what we do in space on the ground applies back to space. So there are multiple tenets in reality, multi-directional, if I can use the word, or responsible behavior. And we try to implement all of them as much as possible based on international space law, on European regulations, and also on the so-called, a word I don't like very much, non-legally binding standards. Well, as a lawyer, I still have trouble in understanding what does it mean non-legally binding. For me, I agree there's either hard law or there's no law. However, what they define, and I don't like to use non-legally binding or soft law, has a purpose, has some effect in the long term in law, because it helps the development of so-called hard law. And that's how I take it, just as for what it means. So as an international intergovernmental organization, we are based on a unique legal framework, which is the ESA Convention. It's a regional cooperation treaty between nation states that implies a high level of coordination, mutual trust, and collective way forward. These words already are a good model that in space, we can have many different nation states with different national policies that work together and have common way forward. If then gives be an example of responsible behavior of regional actors in space. So while many can look at first at United Nations treaties, allow me to suggest a model here. The space law treaty adjusts one part of my own pyramid of the space law. There are many different levels hierarchically organized. And space law is a system of many different levels of hard law. At ESA, we cherish and practice the whole legal system, as space law does not exist as such in space as a bubble, but international law as the UN Charter, space activities, national laws, they all play a role. And also many international system agreements, international organizations, just to name a few, NATO, whatever, they all contribute. They are all involved in the creation of law. Drafting agreements, drafting commitments, guidelines, practices. And here I want to thank again the Space Command, because ESA is one of the party of the sharing agreements STRATCOM we did many years ago, and we see the benefits of that every day. So national laws, as much as procurement contracts, regulation, day-to-day shape and guide our operations. So for me, I have this picture in my office, and whenever I have to explain to some of my colleague engineers, they do not want to understand what law is and why should they follow, I try to give a graphic representation of my pyramid of space law. So ESA as an international actor promotes responsible behavior by voluntarily accepting the rights or the obligation of 3 of the UN treaties, namely the Rescue and Return Agreement, Liability Convention, and Registration Convention, because this treaty allows an international organization to declare the obligations. By setting an example of intentionally doing more than what is required, ESA promotes responsible behavior and therefore also inspires European national programs and others to learn, implement similar notions and similar practice in their respective mechanism. We've been a functioning model of international space cooperation, and ESA takes every opportunity to share in full transparency our own mechanism and the rules how we apply them. For example, we published a conference on paper for COPUOS this year, and the way we implemented the famous 21 long-term sustainability guidelines. For instance, within ESA, space debris mitigation goes beyond what is required in the legally binding, in the so-called no binding instruments. It is done through an instruction of the international organization to all staff that have to comply with space debris mitigation standard. This is important, not just administratively, but when we ESA design missions and programs, we apply all of them. And this has an effect in our own missions, but also on others. I gave you a few examples. We develop and produce the European Union Galileo and Copernicus programs. These are global space infrastructure built from Europe. And we apply these guidelines to them. So it has a global effect. European meteorological and environmental satellites, EUMETSAT, are done applying these standards because we developed them for EUMETSAT, and this is benefiting the US because NOAA is using these satellites together with our partners. In some cases, national constellations, including national security constellation of our member states, Italy, Spain, and Portugal, are as a result applying these kind of standards. So I'm proud to note that responsible behavior has an effect in our organization, outside our organization, in international agreements and cooperation. Through the newly established ideas in Europe, we are also enacting what we call Space Accelerator for better and more use of space by Europe. We are mentioning a few of them. Space for a Green Future, that serves the purpose of having combat one of the most challenges, which is climate change. In Europe, setting up a so-called system of rapid and resilient crisis response to have new sensor developed in all European satellites, combined with aerial sensor to set up a system of rapid response. And another system that we have to develop in Europe is called protection of space assets. That's the way we name it. You understand what it means. To try to contain the hazards of growing numbers of objects, some call it debris, functioning or non-functioning. So to come to finally a European system of functional traffic control to help the protection of outer space and allow for sustainable use of outer space. In this context, ESA draws on the experience of years of activities and operations, especially in engaging space community on space debris expertise. We have a well-known ESA space debris, and I believe yesterday one of my colleagues was linked with you in one of the panels. So all these goals will require a thorough legal structure to be effectively realized in Europe in a secure, certain way, in a system where we have many different member states, different national policy and priorities, different national laws. So the system is quite challenging. And finally, space sustainability, at least something which has a definition. It means the ability to maintain the conduct of space activity indefinitely into the future in a manner that realizes the objective of equitable access to the benefit and use of outer space, preserving outer space environment for future generations. So European legislators right now, and we're helping them, are leading a trend to space sustainability right now with innovative national space laws. So environmental sustainability imperatives drive investment decisions also. And we are living a momentum, what we call a race to the top for regulators. And we're stimulating that so the regulators align to highest possible standards in national laws. And this helps driving also, or give a standard to commercial operators and investors. So the future of space for me lies surely in the so-called sustainable use of space. And finally, in 2021, ESA has finalized its guidelines in so-called safe and sustainable close proximity operations to anticipate incoming situations that will increase in next years. These missions have involved human, such as spacecraft dockings or the shuttle in the past. But however, there's an incoming wave of in-orbit servicing operations in Europe, also by private actors. So they are commercially driven, they do not involve human, but there are also all the issues of vicinity to check. And finally, ESA works on the so-called capacity building in space law. We promote, enhance, and foster exchange on the academic level by professionals through something established already 30 years ago called the European Center for Space Law, organizing different kinds of events, practitioner forum, academics. And responsible behavior is one of the themes of work in which we try to shape and form the generation of decision makers and deciders and legislators in Europe. So we have a quite open range of possibilities that we try to exploit in that sense. And we are, of course, by our nature, a multilateral organization. So we are by nature and by vocation open to international cooperation and exchanges. And my presence this week at the Space Symposium has been very exciting because every day I'm called to another panel of General Counsel. Yesterday with the US General Counsel, and then tomorrow there's another panel about legal aspects of space exploration. So I really thank you for this opportunity. It's a pleasure. I'm learning a lot. And of course, I'm very much available to questions and debate. Thank you very much.
Well, all right. Thank you, panelists, for your opening remarks. I'll begin questions with one that's prompted by a couple of remarks from a couple of our panelists. As I think about the role that state practice plays in how we think about customary international law, AVM Jennings, you mentioned that, you know, if everyone starts to follow it, it's going to become customary international law, but yet we want to keep our cards close to our vest about what we're actually doing or the full reach of everything that happens. And Dr. Ferrazzani, you mentioned, you know, that ESA tries to go above and beyond through voluntary compliance, what you understand the limit of legal standards to be. How do we advise our organizations to go above and beyond whatever the standard may be by way of demonstrating responsible behavior without doing actions in other words, without creating a state practice that becomes customary international law that binds us when we weren't bound before? In other words, how do we build responsible behavior and demonstrate responsible behavior without building new constraints that are not present in the current regime of space law? Sir.
I give it a try. As I said, ESA is an organization of 22 member states. So what we do are programs approved in the name of states. However, we act as an actor, has its own legal personality in public international law. So my point to get it approved through the ESA Council, I'm saying, authorize me to do it. I'll do it as an ESA, as a scientific and civil organization. You're not bound. It's not yours attributed to your own state practice. Let me do it. It has no legal meaning. Sometimes I succeed. Maybe sometimes some of the member states tell me, wait a second, if you do that in the name of Europe, then I will be recognized to having authorized you to do so. So there's a fine line and balancing in that situation, but certainly being a civil and R&D agency allows us a certain margin of maneuver of non-direct attribution to all the member states. And this allows us to experiment. And we've done it anyway with the famous Space Debris Conference for many, many years. Europe had no position on space debris for many years. Now there are policies, they're very good ones, they're thought. But for many years, we had a space debris prediction and office. We did the operations because we were doing the operations. And without them being attributed to one common and unique position of all our 22 member states.
So I think it's a really difficult question because there is this delicate balance between wanting to be a responsible actor and to also, if you like, set the parameters and set the standards for others, while at the same time preserving your freedom of action. So not limiting yourselves by being too prescriptive about what that might mean. So I think in practice, how you do that may well be to be slightly more, to work out which things you would want, you would be happy or happier that would be reflective of state practice. There are some things, for example, traffic management, where actually the self-interest of all of the states means that setting something that might, a norm that may evolve into, you know, a state practice may well actually be beneficial, whereas in some elements, it may be, you may wish to keep your flexibility of action a little bit more. I mean, the reality is for me, the law will always develop because it will always look at what everyone's doing. So, you know, you can't sort of sit there and go, well, we're not going to do anything because the law might develop. The reality is it will develop irrespective. And so it will just watch what you're doing. What you need to try and do is preserve that left and right of arc as wide as possible for your commanders, so that that policy overlay can then help decide where you want to go. So I think there is something about holding your cards to your chest, but there's an inevitability about this. The more we do, the more people will see, the more that people will think that that reflects state practice, and that will become customary international law. And I'm, you know, picking up on what the professor said, I'm not averse, although I have my allergic reaction to the phrase soft law, it's not that I don't recognize the utility of starting those difficult conversations. And I think we need to start those difficult conversations. And actually the UN piece is a really, really valuable way of doing that and bringing people with different views to the table and starting those conversations that at the moment have been, you know, fundamentally stalled for a number of years and very difficult. So however we can do that is great, but I think there's an inevitability about state law developing as space develops further.
I have to. This is such a great question because it's a typical Todd Pennington. What's he asking again? I truly think that practice and custom drive good treaties. If we can agree that the treaty is a codification of principles and not so much actions and custom. I know that sounds weird, but when you think about the Outer Space Treaty, for instance, the granddaddy of them all, the one you all go back to and love and can cite verbatim, why is it such a good treaty? Because it's principles or it's norms, whatever we want to call it. But it isn't necessarily a codification of do's and don'ts. And frankly, that's where we run into problems all the time. And as you heard the discussions over the last couple of days, there was discussion about, okay, what can we all agree on? I think it's easier to say, what can we all agree on that's wrong, right? So let me pick on Pennington a little bit because we go way back. Hang with me here. Who, what, why, when, where, and how? What happened? If it's an individual crime or if it's state practice, if you ask those fundamental questions, okay, tell me what the state did, who was responsible, where did it happen, how much did they blow up, how much damage did they do, how many civilian casualties? We know all those. When you start asking those questions of who, what, why, when, where, and how, you get away from this. Responsible behavior, due regard, space debris, soft law, harmful interference. Ladies and gentlemen, those are all end states. And when you come up with a list of things that are really bad to do, you can define what that end state is. You're looking for action, and the law always tries to proscribe actions in a negative sense that then become those end state definitions of what we've been talking about. And this back to what we've been talking about last couple of days. Yeah, but you won't tell me what you're doing. Who, what, why, when, where, how is all classified. So how do I know if that's right or wrong? Usually it is an end state. So that's the difficulty, I think, of driving the fundamental question you asked. Why is this so hard? Because practice and custom drive principles in treaty and in space. This is what drives my boss is crazy. This overclassification of things in a world where we have to deter. How do you deter? How do you integrate that deterrence if you can't message? The fundamental underpinnings of deterrence is messaging. But I can't tell you what I'm doing. So what's tough about this is you have to message, you have to declassify, but then how do you stop short of sharing your methods and means? Probably more important than that, your tactics, techniques, and procedures in military parlance. It's a great question.
Just add, in terms of deterrence, the other fundamental bit you've got to have are some consequences. There's got to be something that could be done. And I look at everything we've talked about over the last couple of days, and, you know, the real cynic in me goes, so what? What's the point of us, you know, really turning ourselves inside out about what the law should be, whether it's soft law, hard law, what should we do, how should we behave? Because guess what? Actually, when push comes to shove, what I'm seeing in Ukraine at the moment, our adversaries don't care. And what are we doing about it? You know, where's the enforcement of the law? So I do, you know, that's the cynic in me. What's the point? Because actually, if you can't do anything about it when someone doesn't follow it, when it's an accepted, you know, international legal standard that it's broken, and you can't do anything about it in a meaningful sense, apart from perhaps hand-wring and suggest you might prosecute some people at some point in the future, possibly, what's the point?
Thanks, ma'am. I'm pulling myself back together after those thoughts. I'm going to try to carry on with moderating here. I'm going to resist the temptation to pose the cheeky question I had in mind of General Rockwell about the future of a Space Force JAG Corps. I'll save that for the happy hour. Find us down there and watch me embarrass myself as I pose it, because I want to leave time for questions from the House and the online audience. So, Major Gruner, do we have questions from the online crowd? Let's start there.
Sir, we do actually have a couple of interesting questions, but I'll start with one that I think could be answered by anyone on the panel. This is from Eduardo Bisson. He says, I agree with the definition of law being a framework to regulate behavior. However, what is the role of justice in the definition of law? Law without justice ingredients might be reduced to just about anything that is written on a piece of paper. Justice, fairness, seems like those should also apply in space or to the space domain. Or is it a new domain that's devoid of these fundamental concepts? I think that this may go somewhat to the question of the language in the Outer Space Treaty with respect to the use of space being for the benefit and to the interests of all countries. But what would the panelists say to Mr. Bisson about justice and fairness?
I think it's my fault since I used that phraseology. So I'll take first stab at it. It'll be short. I don't differentiate law and justice. If something is unjust, then it can't be lawful, and it can stay lawful for a while, but it won't survive under its own weight. So law and justice to me are really synonyms. So if you're using the term law, rule of law, it has to be just, or it's not going to last. Our society's not going to last.
And the only thing that sort of goes in my head is, you know, when we talk about justice, and I don't disagree that the two are intrinsically linked, but when we talk about it, who are we talking about it for? Justice for who? You know, freedom or fairness for who? Because, you know, I look at how we've developed laws over the last few years, and it's, you know, it's justice for the person who is developing the law. And there's always somebody who's got a different perspective who doesn't think that's just. And that's what we wrestle with internationally. And it's different to our domestic situation where the people who think it's unjust are generally the criminals, for example. In the international arena, there's always someone who thinks they're just and someone who thinks that they're not, because that's how you have war and conflict. And that's why we're all sitting here in uniform. There's always someone who's got a different view on what that looks like.
As to perceived justice in space, I want to go back to an earlier comment from John Rockwell that I liked a lot, indicating the law is a system of behaviors. Absolutely true. But why do we write the prescription of behaviors? Because even before behavior, we have a judgment, which is a social and moral judgment of common shared values. And once the values are common, then we write the law and we write how it should be, how it should behave, and then the law can be principles or more prescriptive into behaviors like national laws and so on. And I think that the Outer Space Treaty and all the treaties along write just what has been felt, the right and the common values. So justice is that the values are written. And I find it very positive that we have common values written and applicable to all, because it's quasi-universal application of the space law that we have. Of course, it's principles, it's not complete, it's not detailed, and it should not be, because if we were to write all the prescription to the lowest level, there will be no common values among the people of the world, because they're not. So we have to be content and very happy to apply the common values and follow them, including the idea that we can recognize and meet each other, all the communities around the world. And this one happened already in the so-called guidelines for sustainable use of space. So I'm relatively happy to see what we have. Of course, we have to be also wise and tolerant that this is not totally complete, but that's the world. That's the way the world is.
Thank you. Great discussion. Do we have a question here in the house?
Major Tirado, Air Command and Staff College. My question, I believe, is mainly targeted towards General Rockwell, but I think anybody could also chime in. Sir, you mentioned whether norms versus rules really matter to our operators, and brought up the concept of how we, to an extent, lack an enforcement mechanism. I'm just thinking that to an extent, the Department of Defense is an enforcement mechanism. And if we were to stay in the realm of norms versus codified rules and laws, are we not thereby hampering our ability to militarily respond and, I guess, limiting our freedom of action if we don't move towards more of that codified versus norms, and how a violation of a norm is definitely not the same as a violation of a law and our ability to respond?
Yeah, I think transparency is so critical to what we do. We are a military organization who has given an incredible amount of power to do things that, frankly, in a democratic society, rule of law society, is a pretty massive power. So to your point about what our operators think, look, if we're not transparent in the way, hey, this is the way we're going to do things, this is the way we'll lay it out. The challenge I give you as lawyers is, does it really matter if it's a norm or rule, and can you really explain the difference? At the end of the day, it all comes back to one thing, and that's transparency and trust. We are inherently not transparent and not to be trusted. And I think that's healthy. Why? Because we're given a lot of power and authority to do things. So the norms are critical, the rules are critical, the principles in a treaty are critical, as long as they lay out, this is the way we are going to act with this immense amount of power you've been given us. So the challenge I give you is it's not the semantics, it's not the form, it's the substance. And at the end of the day, guess what? We may follow those norms to a T, we still won't be trusted. We'll still be viewed as not transparent because of some of the discussions we have, but that's okay. That's the calling and the standard we have to raise ourselves to as we enter into this new warfighting domain of space. Thanks.
I suppose that my only reflection on that would be, there's got to be more, I think, than just either, in my perspective, the Ministry of Defence, or from your perspective, the Department of Defence, as the enforcement mechanism for everything that goes on in space, because that's a pretty big sledgehammer to crack a nut in a number of cases. And if you know, my sense is the military a bit of a break glass moment. You know, we're not the world's policemen. That's not our role necessarily. And so I think we have to be really careful about when we deploy that military instrument. As you say, it goes to that trust. The world won't trust us if we deploy our military instrument willy-nilly. It's an English phrase. You know, at will, whenever we feel like it. You know, it's got to be the considered use, the political, you know, the military instrument of the political arm. We need to use it when we need to break glass, because when we haven't historically, certainly in the United Kingdom, we have come under some really significant scrutiny and criticism.
All right. Another question here in the House.
So listening to everything over the last couple of days, I think from my perspective, the billion-dollar question is it worth it for the US, the UK, Europe, others to continue to push for a rules-based order in space, given what we've talked about with the challenges of doing that, of defining what that is and getting others to comply? Because that's something that I'm hearing from certainly a political context, is there's a desire to do that. But, you know, I guess there's always going to be obviously there's complications, it's hard to do, but I'll be interested in personal opinions on whether or not that is still something you think is worth fighting for or pushing for.
I'll try to start that as saying absolutely yes. Rule-based systems is the very nature of our states, of our people, our democracies. All our systems are built and are developed on the idea that there are shared values, as I said. The values are in the rules and in the behavior of people. And actually, this is also what ties us together internationally. If we have a coalition of many states, of many forces, be them economic or defense, it's because we have common values. That's where we recognize ourselves. This is what we're doing in Europe, trying to develop a progressive integration of European people, states, government, policies, the economic freedoms, all those things. This is all rule-based. It's a matter of mentality. And that's how, I have to say, the rest of the world, when they have a choice, they choose that when they have a choice.
So I would, you know, for all my cynicism and everything I've said about, oh my gosh, this is terrible, what's the point, let's all go home. I absolutely think that there is still absolutely a point for, you know, that it's absolutely relevant to have a rules-based system, because what's the alternative? It is chaos, and nobody wants chaos. So I'm absolutely in favor of it. And I think there is something about shared values, but I think it goes beyond that, because we don't have shared values with everybody. I look at some of the people who we would consider, you know, as main operators in this area, you know, China, Russia, India coming forward, and other nations. We don't necessarily have shared values that we can rely on. We have a different understanding of the law. We have a different understanding of where the law sits in our society. But what we do often have are shared or common interests. And I think if we can leverage that, I think we stand a good chance of actually moving this dial and keeping moving this dial to get further clarity and international agreement. So I wouldn't give up, but I think we need to accept it's a slow process, because we don't all talk the same language, literally and figuratively, but it's absolutely worth it.
Same for me. Exactly. And I think you need to take these discussions to the next level. How do you take them to the next level? Rules-based, law-based, rule of law is who we are, right? So we all agree on that. In fact, we can agree a little bit easier because we're common law-based societies, our philosophical system, than perhaps continental Europe. It's not right or wrong, it's just differences. And when we start having these comparative law studies, and here's the deal, Brian, it's approach. It's our approach to the law where we can agree to disagree, which frankly is, in a sense, diversity, which frankly, is what makes us powerful, the debate. When we force this then to the next level, which is agree to disagree on our approach to the law in a comparative law study, we start calling out what I like to call lawfare in a pejorative sense, because the law should never be used as a cudgel. Due process should never be used. Allegations and accusations should never be used. That's fundamentally where I would say, from an alliance and a partnership standpoint, we all think the same. It's the common values as we talk about. And then you get to that next level of agreeing to disagree amongst your allies and calling out things from a competitor standpoint.
And we've been doing that for years. Space might feel new. We've all said it isn't really new, but it's, the emperor's new clothes. But fundamentally, that's what we've been doing for years. We've been working together as allies and partners, and we've always had different interpretations of the law, and that's been some of our greatest strengths. It's not been a weakness, and neither should it be in space.
The issue I have with these two, they don't spell behavior right. And we can spend 3 days talking about that when we get together. So yeah, it's typical of lawyers.
And don't get me started on your use of the word "you" on every other word as well, and aluminum.
For behavior, and that's what we practice every day on the most beautiful example of space operation, that is the International Space Station. We do together as allies, we build it together. It's a magnificent example of peaceful relations. And for behavior, we use another word there. We use it, crew code of conduct. And even if it's a technical document that we, the lawyers that follow it together, colleagues with NASA and the other agency, it is an example of common behavior that's soft law. In reality, is going to become the basis of future example I just discussed yesterday of future common operations on Lunar Gateway and on surface operation on the moon. Human conduct on the basis of the experience of 20 years of space operation on ISS and future operations on the moon. That's a great example how we end up maybe one day writing a code of conduct for all human envoys in outer space based on ISS crew of conduct.
I think we may have time for one final question for one final panelist. It's probably going to take us over, but Jeff didn't get here in time to stop me. We have one from online, Jeremy?
We do, sir. There are several from online, so apologies to anyone whose question I didn't get to. We're going to take this question, though. If the UN Charter is the top of the legal pyramid, Dr. Ferrazzani, when a nation violates that international treaty, perhaps a treaty that's lower down on the pyramid, how are those violations enforced? And what are the consequences to nations that violate such a treaty, especially if the violator sits on the Security Council with the ability to vote?
What in the world could be on their mind?
I do not need to give you examples that happen every other day these days. We know the system, we know the charter, we know Chapter 7, we know what is the Security Council, and we know also the inability of enforcement of international law. I would say partial inability, because there are ways to do it. As we know, there are sanctions, but there are also ways of having peacekeeping operations. There are ways in which there's a international legitimacy for many kind of international action. So in a way, we're not yet there with a complete enforcement mechanism, but look back 50 or 100 years ago. Today, we are much better than we were a century ago. So let's be, in a way, I say happy, and but then in more demand to develop a more complete system of international law, which includes, of course, justice and enforcement. We are not at a national level, but of course, there's a lot more to be done, but we have to give more work to the future generation of lawyers, right?
Panelists, thank you so much for your perspectives today. This has been a really insightful time. Jeff, I'll turn the floor back to you.
Great, thank you very much. The negotiators say you're supposed to start with why, but I think it's okay that we finished with why. So I want to thank you very much for that conversation that I think really brought us back to the core of everything that we've been discussing over the last couple of days.